Hello, everyone. I'm going to go ahead and get us started here, unless Nate, you were hoping to.
All I'm doing is introducing Kelly Bourne, who's going to get us started here. So, Kelly, thank you so much for doing this. And thank you, David, for joining us. But I won't steal Kelly's thunder by singing your accolades. I'll let her do it, and I'll get credit by transitivity. So I'll join back in when the questions come in.
Perfect. All right. I will be happy to share David's accolades and to say, first, thank you everyone for joining us today for this conversation about the global spyware crisis and how to stop it. I'm Kelly Bourne. I direct the cyber initiative at the Hewlett Foundation and have been an affiliate here at the Stanford Cyber Policy Center for a bit. So we have been doing these webinars collaboratively, and I'm really glad today to have David Kaye here to join us. He is a professor of law at the University of California, Irvine. And before that, he was the UN Special Rapporteur on the promotion and protection of the right to freedom of opinion and expression. And so today we're going to be talking with him about questions around targeted surveillance, leaving aside the issue of the sort of bulk interception and collection and retention of private data, or the issues around mass surveillance that we often discuss here. And this question of the private surveillance industry or the spyware industry has been in the news a lot lately. I think perhaps most notoriously with the Pegasus malware, and that was identified from the Israeli NSO Group that was implicated in the killing of the Saudi journalist Jamal Khashoggi this summer. But Pegasus has been used to target rights activists and journalists and lawyers in, I think, more than 50 countries was revealed this summer, at least, including the Saudi royal family, many hundreds of politicians and journalists and human rights activists. And of course, NSO Group is just one of what Privacy International has identified as over 500 companies that are developing and marketing and selling these kinds of products to government purchasers. Which has led some to call this the golden age of surveillance. And we've seen even democracies exporting some of these surveillance technologies to authoritarian regimes. And so this has raised a lot of important questions about how to better govern these technologies, given that now they are being deployed with very low levels of transparency, very little regulation, and basically no controls on exports. And so David very thoughtfully earlier this summer had called for a moratorium on the sale and transfer of spyware technologies until a global export regime has been in place, and laid out some really thoughtful ideas about what that export regime should entail. So I want to turn it over to David now to talk more about this. I think David's going to talk for 30 minutes or so, and then we'll make sure to leave time for Q&A. So if people want to go ahead and enter their questions in the chat box at any time, I'm happy to try and moderate those as they come in. But with that, David, thank you so much for joining, and we'll turn it over to you.
Great. Kelly, thank you so much. I'm not texting. I'm going to start my little timer here, because when I say 25 or 30 minutes, I almost always go over, but I also wanted to start, and I'm going to share slides in a second, by just noting something. So I'm holding my phone here, and when I was putting together slides, I was thinking about starting with a picture of my phone, including a picture of all the apps that are on my phone, and as I was doing that, I kind of had second thoughts. Do I want to share all of my apps so everybody knows what's on my phone? And that's really not content, right? I mean, that just shows the apps that I have on my phone. And it turns out that might be a good place to start here. And at this point, let me share my screen. So I'm looking at this rather than at myself. A company takes advantage of a device's security vulnerabilities when we're talking about spyware. It takes advantage of the phone so that, a company like the NSO Group, which developed the Pegasus software that we'll talk about, it developed this way of getting access to everything in our phones, right? And it installs malware, spyware, if we want to call it that, and it's able to gain access to everything on the phone and to defeat our typical tools of security like encryption. Maybe it's done through a phishing exercise, maybe it's done through a link that somebody you think you know sent it to you and you click on it. Maybe it's through what's known as zero click, which is you get a phone or a message, and the mere receipt of that message provides access to your phone to install the malware that we're talking about. Today, most of what I'll be talking about is the way in which this happens and the learning that we've really developed over the last several years around particular kinds of devices, particularly mobile devices, phones and tablets. But the spyware crisis goes well beyond the issue of our phones. Of course, it involves facial recognition on every street corner. It involves access to laptops, access to PCs. It involves all sorts of ways in which companies have developed tools to gain access to our lives as they are held in our devices. So as we think about this, I want to start really, and what I'll try to do today is identify the nature of the problem, which Kelly, you already really nicely laid out the nature of that in a much briefer, more elegant way than I will right now. We'll talk about the nature of the problem. We'll talk about how we know about the problem. I want to talk a little bit about some particular examples. And then we'll talk about the law, what is in violation when we're talking about spyware, and finally talk about some potential solutions. Okay, so as we're thinking about this, I want to start with Ahmed Mansour, who is an activist in the United Arab Emirates. Now, he in 2016 was found to have had his devices infected by Pegasus. This was discovered by Citizen Lab. Citizen Lab will come up a couple of times in the course of my talk. Ahmed Mansour, again, an activist in the UAE. This wasn't the first time that he was subject to digital surveillance. In 2011, through email that he received through his computer, there was an attempted intrusion. One in 2012 tried to do a similar kind of thing. And these were from different companies, not NSO Group. One is known as Finfisher, the other Hacking Team, which many of you may have heard about in the past. And of course, in 2016, he was identified by Citizen Lab as $1 million dissident because the UAE had purchased this tool, the Pegasus tool, from the NSO Group in order to try to infect Ahmed Mansour's device. Now, Ahmed was, kind of alive and alert to this potential problem, and so he reported it to Citizen Lab. Citizen Lab did the forensic work and was able to identify what had happened. But this is an early example and one of the first examples publicly that we had of the use of the NSO Group's tool. Now, NSO Group is a company like the other companies that provides what they present as lawful interception technologies. As you see here in their about page, they develop technology to prevent and investigate terror and crime. That's the presentation that they make. The problem is that there are really endless examples right now of this tool of Pegasus being used beyond the objective of preventing and investigating terrorism and crime. And how do we know this, right? How do we know about the existence of this tool? And I think this is actually an important part of the story. We know in part the existence of Pegasus and its capabilities through forensic investigations led by Citizen Lab, also by Amnesty International's tech team, by R3D, an organization based in Mexico City. We know from forensic work of human rights organizations that tools like Pegasus are being used worldwide. We also know from reporting. So the New York Times ran a real blockbuster story after working with Citizen Lab and others to identify the massive use of Pegasus against Mexican journalists, families of journalists, against opposition figures, against lawyers, against even UN officials operating in Mexico. So you have, on the one hand, human rights organizations doing the forensic work. You have reporters doing this enormous reporting work around this. And then this summer, we had the Pegasus Project of Forbidden Stories, which was and is, it remains, a consortium of about a dozen media outlets from around the world that did reporting and discovered through a leak a list of a massive number of phone numbers that were identified as potential targets for Pegasus. Now, their number, which is in the tens of thousands, doesn't mean that each one of those numbers is associated with a phone that was actually infected with Pegasus. But the reporting and the work with Amnesty's tech team and Citizen Lab showed that there were at least several dozen actually found to have been phones actually found to have been infected by Pegasus, and it spanned the globe. So we see that there's direct attacks on journalists and dissidents. Kelly mentioned Jamal Khashoggi. What we do know, again, from forensic evidence, is that the people around Jamal Khashoggi, including his fiance, including dissidents who he had been in conversation with, were subject to attack and infection by Pegasus. We know, actually, this is just from last week, that Ben Hubbard, a New York Times journalist, had been subject to a Pegasus attack even this year. And this wasn't the first time that he was subject to attack. We know from the Pegasus Project stories, and this was a story by Stephanie Kirchgassner in The Guardian, right at the time of the release of the Pegasus Project reporting, that Corinne Kanimba, the daughter of Paul Rusesabagina, who you may know his story from Hotel Rwanda, who was essentially lured into Rwanda and is now he was recently sentenced in September to what amounts to life in prison for under allegations of terrorism, which his family and other observers strongly resist and reject. But Corinne's phone, it was discovered, had been infected by Pegasus as early as, and maybe even earlier than January of this year. So we have journalists, we have dissidents, we have activists, we have, in the context of India, at least 161 names associated with numbers that were identified as being on the list of potential targets of Pegasus in India. So all this is to say that we have a tool that has this vast capability, this enormous capacity of getting access to our devices, something I think that if you've been following the news over the last several months, you know this exists already. We have it operating in an environment that is largely lawless. Now, a little over 2.5 years ago, I issued a report when I was Special Rapporteur on freedom of opinion and expression to the UN, highlighting the nature of the problem, focusing not just on NSO Group, but focusing on the range of tools that are available to bad actors in order to conduct this kind of targeted surveillance. And I made a number of recommendations, which I'll come to toward the end. Earlier this year, in the wake of the Pegasus Project reporting, Michelle Bachelet, the Human Rights High Commissioner for the United Nations, said that spyware like Pegasus is incompatible with human rights. A number of UN special rapporteurs repeated earlier calls that I made, and Agnes Calamard, who was then also a special rapporteur on extrajudicial killing and is now the Secretary General of Amnesty. We had both earlier called for a moratorium on the use and the transfer of this surveillance technology. And that's been repeated again most recently. Okay, so that kind of sets us up for the nature of the problem that we're talking about. So what I want to do now is kind of take a step back and think about the legal issues. You know, on the one hand, it's possible to say, oh, of course, and I think this was certainly true in the wake of the attacks of September 11th, so over 20 years ago, that people were willing in a way to be subjected to a kind of surveillance in light of the fact of this of the mass terrorism that we saw. But over time, activists, governments, reporters, journalists, and I should footnote here to note that today is the International Day to End Impunity for Attacks on Journalists. So this is actually particularly timely to talk about this. But we know, and we're starting to see that people understand that these attacks, that this kind of targeted surveillance implicates some real fundamental human rights. And I'm going to make reference to just two or three of those rights in the context of the International Covenant on Civil and Political Rights, a human rights treaty, one of the central treaties in international human rights law. The United States ratified it in 1992, so the United States is a party to it. Article 17 of the ICCPR says that no one shall be subjected to arbitrary or unlawful interference with their privacy, family, home, or correspondence, and everyone has the right to protection of the law against such interference. Okay, so on the one hand, we have, I think quite obviously, the question of whether such attacks, whether such interference with privacy, it amounts to an arbitrary or unlawful interference, and we'll come back to that in a bit. The other set of rights, particularly on a day when we're talking about democratic institutions, freedom of expression, the right to access to information, is the right to freedom of opinion and expression. I mean, really two independent rights, right? Article 19 says, one, everyone has the right to hold opinions without interference. This is an absolute right. In other words, it's not subject to any restriction by the state. And we could talk a little bit about what that means, but of course, so much of what we consider to be our opinion these days, we hold on our devices or we store in the cloud. And so there's a certain level of protection, of privacy protection, that we should expect around those devices, in particular because they do hold our opinions. Now, the one that is certainly resonant on a day where we're thinking about attacks on journalists is Article 19's paragraph 2, which is everyone shall have the right to freedom of expression, which means the right to seek, receive, and impart information and ideas of all kinds, regardless of frontiers and through any media. I don't want to dwell on this, in part because we just don't have the time, but this is a real robust statement of the right to freedom of speech, to freedom of expression. If you think about the First Amendment right and how it says that Congress shall make no law, right, infringing on or abridging the freedom of speech or of the press. Here we have a similar statement of the right, but it's flipped around, right? Because instead of it being directed specifically to government restriction or limitation on government, this is framed as what everybody has a right to. Everyone has the right to freedom of expression. And that framing also, I think, really speaks to the digital age. Seek, receive, and impart could be, browse, download, and tweet if you want. So the language here is robust, and it's a real strong protection for freedom of expression. It's something we should keep in mind. Now, the one thing, and this is, of course, different from the First Amendment in the United States, is that paragraph 3 of Article 19 does say that limitations on freedom of expression, not opinion, but freedom of expression, are possible, right? They may exist. And in the freedom of expression community, as it were, we think of this as a 3-part test. And it says that freedom of expression may be subject to restriction, but only where they are, 1, provided by law, 2, are necessary, and we think of that as necessary and proportionate. And that's in order to achieve these specific specified objectives: the respect of the rights or reputations of others, the protection of national security or public order, or public health or morals. Okay, I'm not going to spend a lot of time on these rights, but I think it's useful to think of these rights as we're thinking about Pegasus and the tools that need to be available to restrain it, because there are a number of questions that arise in the context of tools like Pegasus. And let me go through some of the problems that we might identify here, and then we'll get into some of the solutions. So the first question, I think, is spyware like Pegasus regulable? Is it and can it be subject to real robust regulation? And the reason I ask that is if you go back to the language here, particularly to paragraph 3, we see the 3-part test, and I particularly focus on the issue of necessity and proportionality. And if you think about other tools of surveillance, even surveillance in democratic societies with real strong rule of law protections, we do have tools, the wiretap as one example. And in order for law enforcement authorities to get access to a wiretap, they have to get a warrant, they have to get approval from judicial authorities, and that's common in many democratic rule of law dominated societies. And those tend to be specific, right? So the right of access to someone's communication is going to be specific to a particular kind of communication. And the question in the context of a tool like Pegasus, again, remembering that the access that Pegasus gives law enforcement authorities or other authorities, or just anybody, a leader who wants to spy on his ex-spouse, as happened in the context of the United Arab Emirates, the access to this device isn't limited to that one particular communication. And that's a problem and raises a question of whether spyware like this is even subject to or can be subject to regulation. What are some of the other problems here? There's weak, if any, export or vulnerabilities market controls. In other words, there's no global export control. There's no control on, if you remember at the very beginning when I talked about the way in which a tool like Pegasus or any other kind of tool that gets access to a device makes use of security vulnerabilities on that particular device. There's obviously a market for those, a 0-day market for vulnerabilities, which is, this would maybe subject for a longer discussion than we might be able to conduct here. But there's a question about whether that market should be subject to any kind of control, given the fact that these are taken advantage of in order to create the malware. In any event, the export market is really extraordinarily, or the export controls are extraordinarily weak. A third problem, companies are operating largely in lawless environments. So this isn't a question just of the demand, right, or the export environment that we're talking about. This is about companies that are operating in domestic environments where there's simply very limited control over the use of the technology. This is a fundamental problem. There's limited, if any, oversight of domestic use in many countries around the world, certainly in the vast majority of those countries that were identified in the Pegasus Project's reporting on the use of the tool. On top of all this, victims typically lack access to remedies. They lack access to justice. There's extremely limited, if any, accountability for the use of these tools. We see this, for example, in the context of Mexico, which, as I alluded to earlier, there's a very serious crisis that became public in the summer of 2017 through Citizen Lab and New York Times reporting that highlighted the use of Pegasus against all sorts of actors. There's been almost no oversight of that, and there's been no remedy that's been available to any of the victims of the use of the tool there. And then finally, one other point that I would highlight here is a technical problem, which I'll come to again a little bit in a little bit, which is that the issue of sovereign immunity, the tool by which states do not sit in judgment, essentially, or courts in one state do not sit in judgment of the actions of other states. Again, a subject for a longer discussion in public international law, but sovereign immunity principles have tended to hinder transnational litigation, and that's made it very hard. And there's an example that I'll point to in the context of the United States, where those principles have made it hard for individual victims of surveillance in one country to seek remedy against an actor who's used the tool based in another country. Okay, so a global problem like this requires, I think, global and national solutions. One of the problems is that we've had essentially silence from governments. When I presented my report in 2019, the response was, yes, surveillance is a problem, but there's been very little since then. There's been no state that I'm aware of that has spoken up in favor of the idea of a moratorium on the use. And the reasons for that are not, I think, too difficult to identify. Many governments are afraid that, I think, that going down the path of regulation of private surveillance, of the private surveillance industry and surveillance tools like Pegasus or Hacking Team or FinFisher, right, will ultimately lead to a discussion of their surveillance, right? Whether it's GCHQ, whether it's the NSA and the surveillance revelations from Edward Snowden, which, at this point, we're already, 7 or 8 years since we had those, 2013, I believe, since we've had those revelations. And at the same time, of course, people will ask, well, it's one thing for rule of law oriented societies or democratic societies to impose restrictions on the use of these tools and on the export of these tools. But of course, China has a surveillance industry. Russia has a surveillance industry. What kind of impact would a global effort to restrain private surveillance have in essentially enabling these other actors to provide their surveillance tools? So that's one of the, I think, basic problems that is interfering with the ability of states to move forward on this issue. Now, there is an export control, an international export control arrangement known as the Wassenaar Arrangement, which is a non-binding arrangement for conventional arms and dual-use goods and technologies. It does not have a grounding in human rights. It could, and that might be one of the things that we discuss about moving forward. It is, of course, risky because we don't want, at least I don't think we want, to have regulation of the private security industry that inadvertently deals with genuine security tools that do need to be shared across borders in order to protect infrastructure and to protect individuals using devices worldwide. Another potential area, right, where we could perhaps, or at least one area where we could perhaps see some movement is company responsibility to protect and respect human rights. Now, the UN's guiding principles on business and human rights, which were adopted about a decade ago, provide for 3 pillars. One is that the state has a duty under international human rights law to protect individuals in the face of violations of human rights. But the central pillar, right, the main kind of advantage and innovation of the UN guiding principles was laying out a way in which we could think about corporate responsibility to respect human rights. Now, of course, international human rights law by its terms applies to states. It restricts states. But as you recall, when I mentioned Article 19, the rights are framed in terms of what individuals enjoy. And corporations have a responsibility, according to the guiding principles, to respect those individual rights. Now, a couple of years ago, the NSO Group adopted a human rights policy. They also adopted a whistleblower protection policy, which led me to engage in exchange with them when I was the UN Special Rapporteur. And you can go look at that, and I'd be happy afterwards to circulate some links. But this is on the OHCHR website, the Office of the High Commissioner for Human Rights website. My concern with this industry, or in particular the NSO Group, adopting a human rights policy is not the fact of adopting it. It's great if they adopt it. The problem is that they don't subject it to external oversight. So there's a very significant degree of trust us, right? We will conduct human rights impact assessments when we are deciding whether to engage with a particular client. That's what they say, but that's not available to the public. Or they're going to cut off access to their tool if they become aware of particular restrictions or particular abuses of the tool. Again, there's no public oversight of that, which really undermines the importance of human rights impact assessment. Now, there are other possibilities out there right now. There's the possibility that other companies that engage with other parts of the industry could themselves take advantage of legal tools in order to restrain the use of these private surveillance technologies. For example, WhatsApp and Facebook sued NSO Group a couple of years ago. That is a suit that is sort of in train in the Ninth Circuit right now. But this is in part because NSO Group used WhatsApp, right, as a vector to get access to individuals' devices. And WhatsApp argues, I think quite persuasively, that this is an interference with its platform. And hopefully there will be some discovery eventually that comes out of this case that provides us greater insight into the way in which NSO Group operated. Of course, there's other ways in which we could imagine the private sector getting involved. Cambridge University, for example, ended, or at least postponed, a £400 million deal with the UAE because of the Pegasus spyware claims. This was after a UK court really came down hard against the UAE's use. Okay, a third issue, legal oversight and transparency of domestic use. Now, generally speaking, we don't see a lot of legal oversight. However, just last week, the Supreme Court of India initiated a process and a committee to conduct exactly that kind of review, that kind of oversight of the use of Pegasus in India. And interestingly, in its opinion, launching this review process, it said that national security is not, didn't use this language, but is not a kind of magic wand that can be waved and give the government authority to use tools like Pegasus. And I urge people to go and look at this particular opinion. Any opinion on surveillance that starts with a George Orwell quote, if you're the government, you probably should assume it's not going to go the right way. Now, fourth, there need to be remedies. There needs to be access to justice, to accountability, including across borders. Now, I mentioned this before, the issue of sovereign immunity. In the case of Kidane versus Ethiopia, and this was a case in which there was clear forensic evidence that Ethiopia had used another tool, a Finn Fisher tool, I believe, in order to get access to an activist's computer in Maryland in the United States. That activist brought suit against Ethiopia for that surveillance, and the DC Circuit Court of Appeals found that sovereign immunity stood in the way of being able to pursue that claim, and that's obviously a problem for access to justice, and something that we should think about as a tool to undermine sovereign immunity as we move forward. Okay, so I want to wrap up here because I've hit the 30-minute mark, and I don't want to. I want to allow for some Q&A and some discussion, but let me just run through a few ideas here. So, looking forward, states have some responsibility. I think they need to see digital attacks as a fundamental threat to civil society, and they should retool law in that respect. And I think that we do need to ensure that people understand that these kinds of attacks are not just attacks on individuals. They're attacks on the fundamental pillars of democratic life. On a day when I know up at Stanford you're having a democracy day, I think this is important for us to be thinking about, and particularly as the Biden administration is preparing for its December 10th and 11th Summit for Democracy. And I think the Danish government is planning a technology summit about a week before that. This issue of targeted surveillance must be front and center because it's such a clear example of transnational repression. From my perspective, there should be a moratorium on the transfer and use of these kinds of tools, at least until there's a global regulation framework that's set in place. All states should be expected to adhere to human rights obligations. States have to adopt transparency guidelines, disclosing the purchase and the use of such technologies. There needs to be clear legality principles here. Any use of these tools must be subject to independent judicial controls according to clear and rights compliant laws. The Wassenaar arrangement that I mentioned before should be updated to include human rights principles and should be strengthened, of course, to deal with private surveillance industry exports. And of course, something that I didn't mention is there needs to be a way to address the intelligence industry revolving door, where intelligence actors go in and out from intelligence agencies to the private sector. And then finally, we need to remove barriers to transnational litigation. The private sector, we need to see genuine implementation of the UN guiding principles. Human rights policies need to be baked into company practice. This is something that goes beyond the private surveillance industry, but I think is particularly important here. We need to have transparent human rights due diligence, that is impact assessments for the development of tools, for the purchase, for the identification of clients. And all of this needs to be subject to full disclosure, both of the policy implementation and the oversight of the actual impact assessment. There are other tools, other forms of a normative character that we could imagine as well, including tools like the one that has been developed for the private military contractor industry, which is multi-stakeholder and involves private actors, civil society, and governments. Of course, there are further ways to think about litigation. For example, the human rights mechanisms, UN treaty bodies, regional human rights courts should all be a part of moving the normative needle in a positive direction. And with that, I'm going to conclude my talk. Thank you. Anybody should feel free to shoot me an email anytime, and I'm happy to talk about this area. Thank you so much for your time. I mean, there's no way to really interrupt me, so can't. Thank you for that. But Kelly, back to you. Thanks so much.
Thank you so much. That was really a fantastic presentation, as we anticipated. I have a quick question for you, so I'd love to take moderator's prerogative there. And then I think Nate may have a question also, and then want to turn over to some very good questions that we've gotten from the audience. And so for those in the audience, please feel free to keep submitting those. But first, David, would love to ask you, having read your UN report from 2019, which you referenced, and I'll insert that in the chat box in a minute so everyone has access to that. But I think that report really thoughtfully goes over a wide range of surveillance technologies, everything from the mobile device hacking tools like Pegasus that was covered today, to some of the network surveillance tools, to things like Stingray, the international mobile subscriber identity catcher that I understand was used in the Philippines in the drug war in ways that were really not looked well upon. But would be curious, are there particular categories of surveillance technologies that you are most concerned about right now?
Well, I would put front and center tools like Pegasus.
Yeah.
I mean, I do think that, and I'm really glad you mentioned these other tools, because the global surveillance market is quite vast, and governments have, kind of a remarkable toolbox when it comes to conducting surveillance in a way that is not subject to basic rule of law standards. But I do think that the private surveillance industry, as we think about, in particular, tools like Pegasus, that is access to our devices, provides a kind of access that is, extremely intimidating to basic pillars of democratic life. And I think those should be addressed. It fits. I mean, addressing that now fits with, the kind of democratic government kind of policy orientation right now, which is to deal with transnational repression. And I think it's an area where we have a lot of evidence of abuse. We have some pretty good examples of tools that we could start to use. Again, it's not, there are the Chinas and the Russias and other actors who may not ever want to be subject to these kinds of constraints. But I think we need to make a start with that area as kind of a first priority.
Great, thank you. Nate, I want to give you a chance. I think you had a question, and then I'll start going through questions from the audience.
Thank you. And David, I just want to say how fantastic this work is, and I'm so thrilled that you are doing it. I don't think there's, enough of this kind of research being done in kind of formal academia. There's certainly security folks who are doing it, but it is so important. And I think that, just drawing attention to it is so critical. Let me ask you the questions that I always get. I always get three types of questions whenever I give a cyber-related talk. One is, what I think is bad is actually good. The second is what I think is new is actually old. And the third is what I think is an original idea, something someone else has published on already. And so let me ask you the second of those questions, right, which is basically about historical analogies and the extent to which this is part of a larger class of problems, or if it's sort of sui generis, right? So just on the kind of private military grade equipment question, like weapons, right? So that we've often had all kinds of sensitive technologies that have had to be regulated, right? And you mentioned this. And so how different is this kind of surveillance technology? Have we is it such a difference in degree that it's a difference in kind at this point? Or what makes this different than other dangerous technologies that governments have had to regulate in the past that also can be used, by nation states for either intelligence or national defense or, aggressive other measures?
Yeah, Nate, that is a really, really great question. I guess the way I think about this is, absolutely not to disconnect, tools like Pegasus from the history of surveillance over the last, several decades. I don't think of this as this tool, or even the other tools that Kelly had mentioned. I don't think of this tool as, fundamentally different from what governments have tried to do for decades. And, if we think about, in fact, if you think about how countries like Germany responded to the Snowden revelations, a lot of their response to that wasn't just, I'm kind of fearful of my device being tracked, but I connect this, putting yourself into a German mindset, I connect this to the kind of surveillance, right, that took place during the Cold War. And so I think to sort of the kind of what's new is old issue, I think you're absolutely right to raise that question. And I think that's actually a useful place to start. I think the difference with these kinds of tools is maybe there's two kinds of differences. I mean, one is these tools do provide a kind of access that is very difficult to control and to provide oversight for. So whereas, again, when we're talking about, the wiretap as, a quite invasive law enforcement tool, even, extremely useful, and when used appropriately, can be very helpful for all sorts of law enforcement reasons. But, that comes with a transcript. It comes with a kind of paper trail with it that maybe we could see develop in the context of oversight around something like Pegasus. But the problem is that it provides such vast access to everything that is really difficult to control and to identify even, the contours of what that control looks like. I think that puts us, again, it's there's a spectrum, but it puts us into a category of this is a real vast interference with more than one's conversations, but with one's, personal life in very deep and invasive ways. Now, that being said, there are tools out there for global regulation, and it's risky. I mean, I want to acknowledge that up front. Going down the path of restricting software, whether we call it malware, spyware, or something else, high technology does require a kind of proportionality approach so that we don't inadvertently interfere with those kinds of tools that are really important for the security sector, that are important for protecting critical infrastructure, protecting elections, and so forth. So we need to be very cautious, but I think bringing in this element of a human rights framework, which isn't a part of typical, military or dual use technology transfers, I think that will at least enable a way of thinking about restricting these tools that would be different from the way they've been controlled in the past.
Great. Thank you, David. So we have 13 questions and less than 13 minutes left. So I'm going to try and do a little bit of a lightning round, but we'll acknowledge we probably won't get to all of these. But first, there are a few questions that touch around the role of smartphone providers or tech companies in improving security. So one question around sort of affordability, and people are, purchasing, more affordable devices that maybe aren't getting updated as they should be, or questions around should there be more in the realm of private rights of action against tech companies that are selling or distributing, devices with more vulnerabilities. What do you see as the role of these sort of manufacturers in the process? Yeah,
and that's a really good question. And I think one of the things, well, I guess maybe where I would start with that is, I don't think we can say that, well, people just have to be responsible for updating their devices when they're told to update them. I mean, we all should, but I don't think that this problem can be resolved by putting it onto the shoulders of users. But the question of affordability is a really good one, because people around the world use, particularly mobile phones, in a way to communicate, to conduct commerce, to get information, to organize, to learn. I mean, the mobile phone is just a remarkable tool, and the cheap mobile phone around the world, the inexpensive one, is indeed subject to these kinds of harms of direct surveillance, of targeted surveillance. Now, I mean, of course, a lot of the people that have been identified by the Pegasus Project, by Citizen Lab, by Amnesty, and by others are elites, who actually use, up-to-date iPhones. They are, doing what they're supposed to do to update their security. So, this is there is a kind of, there's a little bit of a mismatch in the sense that, most of the people who are talking about as being subject to this are people who are actually in the affordable. They're in in the camp where they can afford the technology. They do. Oftentimes, they're part of newsrooms that devote some significant effort to individual security. So, I mean, I think, we should be thinking about those different kinds of users as we think about the overall problem. And also, the problem that I've identified today is particularly a problem of democracy and rule of law, which again has a kind of not just elite focus, but the people using the tools and who are most subject to the concern tend to be the ones who have that ability to afford. So there are different kinds of issues going on there, but I think it's a great question. The private right of action is indeed an interesting approach. And this gets into how we think about the vulnerabilities market, how we think about how vulnerabilities need to be brought to the attention of companies, how we think about when companies have knowledge of those vulnerabilities, how quickly they act upon it. Is there a duty of care around that? I think there are a lot of interesting pathways that we could think about to kind of create a normative expectation of security in our devices.
Great, thank you, David. And then we have 3 or 4 questions that are looking at, what practically do we think we can get done? So some questions around, how likely is it that governments are actually going to adopt some of these? We've seen even in the case of Assinar that, there's something like 42 countries, I think, have adopted it. There are really no enforcement mechanisms. Israel has not joined, to my understanding. So there's questions around, what practically can get done in broadly. And then a second question, but related around, for really motivated governments, what do we think is possible and most likely there? And then questions also around the UN and what they might be able to do through export controls or otherwise to hold agencies accountable. So you recommended a wide range of things that would be fantastic to see implemented, but what do you think are the 2 or 3 that are most likely and practical to get done?
Yeah, I've got my wish list, and then exactly there has to be a kind of prioritization and a recognition of kind of steps that you can take. And I think there are steps that can be taken, without neglecting that, shopping list that I've got, without neglecting the overall restrictions that we need to put in place. Absolutely, there are some things that could be done relatively quickly. I mean, but each one of them has a kind of counter argument to them, or a if not a counter argument, an argument for resistance, right? So to give one example, I think that the sovereign immunity problem is a real problem. If we put into the hands of victims the ability to bring suits across borders, I think we get into a real good space of developing the normative rules that should apply when it comes to the use of this technology. And so, at one level, in the past, the United States, as an example, has legislated restrictions on sovereign immunity in US courts. There's a history of doing that in the context, for example, of terrorism and material support for terrorism. I mean, there are problematic elements to that, but there are instances, there's a history of doing that. Here we have an issue where the Biden administration has, spoken quite forcefully about the problem of transnational repression. And here's a tool that you could at least, it's a pretty narrow tool, but it is a tool that could be used relatively quickly, through a legislative process, of course. So I guess nothing is quick when we're talking about legislation, but, putting it in train in order to say, look, in the context of one government's use of a targeted surveillance tool against individuals in the United States, that, that should not be subject to a sovereign immunity argument. Of course, the problem is that the United States does conduct surveillance around the world, and it doesn't want it to be subject to those same kinds of suits around the world. I mean, I think that's a cost that it should bear. But, if I were a lawyer for the United States, I might think otherwise. But that's one potential tool. It doesn't have to be the United States that goes down that route. I mean, there are others in Europe, for example, that could, go down this path of opening up their courts to this kind of litigation. So, I mean, that's one area. I would also connect, in terms of steps that can be taken, right? I mean, I do think that the UN, particularly the UN human rights mechanisms, can have a useful role to play here. And so I think that as individuals are thinking about, their advocacy around this, I think part of the advocacy could be conducted in the UN treaty bodies, the Human Rights Committee as a good example, where, if we could identify particular victims in particular states where that state has consented to the jurisdiction of the Human Rights Committee, we could start to develop a kind of, a stream of jurisprudence in those committees. I would expand that to regional human rights courts and other places as well. But we could imagine the development of a normative, kind of normative jurisprudence against the use of this technology, and also provide examples of what appropriate use might be, an appropriate constraint might be. So those are a couple of areas where I think that there's some room for development. Of course, I mean, there was a question about motivated governments. I didn't look at the Q&A, so I don't know what that referred to exactly, but there are many governments that will step in where other governments step out. In other words, there is that looming problem of governments like China and Russia providing similar tools on an open market.
I think we were positively or constructively motivated governments who were looking to solve the problem rather than exacerbate it.
So there is the possibility of the European Commission taking some action here in the European Parliament. The European Parliament has taken some baby steps in this direction. The Indian Supreme Court, I think that process should be something that we pay attention to quite closely. And anybody who's engaged in this space should be, providing support, advocacy, et cetera, to those kinds of, positively motivated governments to engage.
Great, thank you. And we have about 1 minute left because we always try and save 1 minute for sort of next steps and upcoming events. But would love to throw a question at you that relates to what Nate had said earlier about just how thrilled we are that you are doing this work. And as a funder, this comes up quite a bit in conversations with other funders around, who is, and you've mentioned Citizen Lab and others, but there are amazingly few groups really doing research here. And we get a lot of funders on these webinars, and we also get a lot of researchers on these webinars. And I think you'd be in a great position to say, where are the big gaps that you're observing, either geographically or substantively? Where do you wish there was more research right now?
Yeah, I mean, I think this is an area where Ron Diebert, who's the head of Citizen Lab, has said in the past that this is the tip of the iceberg. Yeah, right. I mean, we're
him on Reset earlier this year, which was great.
Oh, so maybe I'm quoting him directly from that. But there's a lot of room to support other forensic work in this area, and I would say advocacy. So right now we have this. I know we're at the very end. We have this gathering set of information. We don't have the solutions and the stream of advocacy that needs to be directed to those motivated governments. And I think that's a space where, one, I would say supporting that kind of advocacy, and two, supporting technologists who want to go work in human rights organizations to connect kind of the forensic elements here and the human rights elements could be extremely helpful to all of this advocacy, in the UN, in capitals, in governments around the world, in courts, and so forth.
Great. So helpful, David. Thank you. And just really wonderful work that you're doing. I've been very glad to get to host this with you today. So thank you so much. Thank you for our audience for joining and for great questions. I'm sorry we didn't get to all of them, but we'll turn now to next steps here. And noting that we're doing webinars every week at around the same time, so you can see who we have coming up soon. And again, David, just thank you so much for the work that you do here and for taking the time to join us today. All right.
Thank you, Kelly. Thanks to everybody up there.